particular purpose? Is it a hobby? Is it a research project? Anything like that?
I don't know yet at the minute.
Okay.
Just sort of flying around, see what happens.
Right. I understand an officer's just tried to have a word with you on the way into the car park.
She sort of shouted at me in a plainclothes personal car, so I didn't have a clue who she was.
Apparently you've told her to pee off.
Did I?
That's what she said to us. If that's the case, that's not acceptable, is it?
Well, that's why we wear independent witnesses that never lie.
Right. What do you mean by that? Right, okay. Well, yeah, I've got mine on as well, so...
Well, thanks for letting me know.
Can I take your details, just so we know what you're doing, and you're recorded on our systems, and we've got the fact what you're doing, and to make sure you're not up to no good?
No, I'd rather not, if that's okay.
Okay. Why is that?
Because I haven't done anything wrong.
Well, I just need to make sure that you're not, like, sort of in line with any terrorist groups or anything like that you could be using for hostile reconnaissance or anything of that nature.
Do you suspect that I'm a terrorist officer?
Well, I don't know until I speak to you. Do I? Until I take your details and check you through.
Is that what you do with everybody?
If you're being verbally abusive to people, then you have technically committed a public order offence, for which I would...
Everything changes the moment they finally obtain ECS personal details. Almost immediately, the tension disappears. There is no more talk about any offense, no further action suggested, and no sign that they want to keep looking into the situation. All the earlier claims public order issues, serious concerns, and references to different legal sections suddenly disappear as if they no longer matter. That quick change makes the situation look very different. If those earlier claims were truly important, they would not have been set aside so quickly once ECS information was recorded. Normally, when something serious is believed to have happened, may lead to more questions and further steps. Instead, the conversation stops almost instantly. This makes it clear that the main goal of the entire exchange was to identify him. Once they hit ECS details, the discussion had nowhere else to go. The legal terms we set earlier did not lead to any real process or outcome. They simply seemed to act as pressure during the interaction so ECS identity could be collected.
Asking you for them as well.
Right.
So can I have your name and date of birth and address, please?
What, you think I've committed a public order offence?
Yeah, because an officer's just told me that you've sworn at her in the street.
Well, I need to get her
Yeah.
to make that statement then, because she's lying.
Well, she's just told me as she's driven in that you've sworn at her.
Did she?
Yeah.
Right, well, I'll be making a complaint about her then.
That's absolutely
And if you
fine.
take my details, I will have to sue West Yorkshire Police.
That's not a problem. You feel free to do so. The reason I've explained the reasons why I'm asking you for your details.
What happens if I don't give my details?
Then you're potentially committing an offence.
Well, I will.
It's a lot easier if you do, isn't it?
Yeah, I don't want to give my details.
Okay.
I will if you tell me that I'll be arrested if I don't.
Well, potentially you may be. Yeah, it may make your arrest necessary under Section 24 of the Police and Criminal Evidence Act because your name and address can't be verified.
Right.
And I've got reasonable grounds to suspect that you've committed an offence.
What reasonable grounds is that?
But I've been told by a fellow officer that you've been verbally abusive in a public place, which would be a Section 4A public order.
I have it all
offence.
recorded, officer.
That's fine.
Do you want me to show you the recording?
Not at the moment, but I want.
Because I could show you the recording.
I want you to.
And then you would know.
Details, and I've explained it to you. You've asked me to explain it to you. And I've laid it out plain and simple.
This is the point where the reasoning starts to fall apart. They say a public order offence has taken place, but not because of anything clearly happening. The claim seems to rest only on what the sergeant says. UN News Now Yorkshire calmly asks what would happen if he chooses not to give ECS details. The explanation goes in circles. They suggest that he might have committed another offence, which might then lead to an arrest. That kind of explanation raises more questions than answers. They also mention Section 24 of PEs, but bringing it up only highlights the issue further. An arrest cannot be based simply on someone's rank or because it is more convenient in the moment. There must be clear and reasonable evidence to support such a step. Without that, the justification becomes very weak. In this situation, the only support for the claim is what another officer has said. Even when video footage is offered that could quickly show what really happened, they choose not to watch it. That decision stands out. When available evidence that could resolve the matter is ignored, it makes the whole situation look less like a fair check and more like a decision that has already been made.
You've been verbally abusive towards somebody.
I haven't though.
She's alleging that you have.
I haven't
As
though.
I said before, I've got reasonable grounds to suspect that you've committed a public order offence.
But I haven't.
Okay, listen to me. Because of that nature, that's why I require your details. And
Right.
as I've explained to you, if you don't give me your name and address, and can't verify who you are, it may make your arrest necessary in order to ascertain those details.
Will you arrest me if I don't?
I'm not saying I definitely will, but I'm saying it may make your arrest necessary.
Am I being detained right now?
At the moment, because I need your details.
Yeah,
yeah.
I'm being detained.
Potentially, if you don't give me your details, you may be arrested, is what
No,
I'm
no,
saying.
no,
to you.
I just want to check if I'm being detained right
I don't
now.
understand why you can't just give me your details.
I'd rather not. That's
Right.
the point.
But I'm asking you to.
If I have to by law, then I will.
You do have to by law, yeah.
Okay, and what section of law says I
I'm
have
telling
to?
you that because you've committed an offence.
I haven't, though.
I suspect that you have.
You suspect that I have?
I suspect that you have. I
Okay.
only need reasonable grounds to suspect. That's 2 to 3 out of 10 on the scale of 1 to 10.
Yeah.
I've got that reasonable suspicion.
Yeah,
okay?
yeah, yeah. Can you let me know that lady's name or collar number?
So she's a sergeant who,
Yeah.
who was off duty at the time, coming into work for whatever reason. I don't know
Yeah,
why.
because
but she's a police
she's lied
officer.
to you. Now you
Right.
threatened me with arrest,
Yeah.
which has now made me have to give my details. So I will have to make a call to my solicitor.
Yeah, that's absolutely fine.
Yeah, okay.
You go right ahead.
They tell him that if they cannot confirm who he is, they will arrest him in order to find out. But that is not how arrest powers are meant to work. In the situation, Mitty looks more like the officers simply want which is details and are seeing the possibility of arrest to obtain term. An arrest should not be used as a shortcut to deal with someone who chooses not to cooperate. For an arrest to be justified, there must be clear and reasonable grounds supported by real evidence. BT should never depend on a single anti-state claim or a assumption. When the only basis is a suspicion without proof, those reasonable grounds stop being reasonable and start looking like a convenient excuse. Facing the possibility of being taken away over a weak explanation, he eventually provides HS details to prevent the situation from getting worse. Mitty is not because the law clearly demands AT in that moment, but because the pressure around him keeps increasing. When someone agrees under that kind of pressure, Mitty cannot really be called a free choice. Mitty is simply a way to bring the
I can't believe she lied to you, officer. I have got it all recorded though, just
That's
so you
fine.
know.
You can, if you want to make a complaint.
Yeah, I will
about
be
it,
making a complaint
yeah,
straight away. Yeah,
that's not a
definitely,
problem.
definitely.
I haven't got
Is that
any
what she
issue with
actually said to you? I told her to pee off.
As I drove out of the gate, she was driving in and she said, "Will I have a word with you?"
Yeah.
Because she'd spoken to you and you
Yeah.
told her to. I'm not going to say the full word.
Yeah,
but
yeah,
pee
yeah.
off. You understand what I mean by
I
that?
understand what you're saying, but she's lying to you. You know that, don't you?
Well, if she's lying to me, she's lying to me. If it's on your camera, then you've got grounds for a complaint. Then
Yeah,
haven't you?
100%.
But
Yeah,
I'm not lying
yeah.
to you. I can only go about.
You know,
what
last
I've
time
been
this
told.
happened, I got £1,000 for it, you know?
Right.
Yeah, that was at Humberside though.
What was that? What was that in relation to though?
Because someone said I was committing antisocial behaviour, so the officer unlawfully used Section 50 of the Police Reform Act
Right.
to gain my details, just like you've unlawfully used Section 5 to gain my details.
Okay.
And then they offered me £1,000 for my trouble.
I haven't used Section 5.
Oh, did you use?
You've potentially committed an offence under Section 4A of the Public Order Act.
Oh, okay. Section 4A.
Yeah.
And that
doesn't
requires
get-
me to give my details.
It doesn't require you to give you details.
You just
What
told
I'm-
me it did.
What I'm saying, no, you're twisting my words.
The officer keeps leaning on the word potentially. Potentially an offense, potentially a problem, potentially linked to Section 4A. That single word carries the whole argument because there is no clear evidence being presented. Simply saying something might have happened is not enough to prove that an offense actually took place. Section 4A requires more than the possibility that someone felt offended. BT normally involves clear intent and a real effect on the situation. Guesswork or assumptions do not meet that standard. Without those elements, the claim starts to look uncertain rather than solid. What makes the situation more confusing is that the legal section keeps changing. At one moment they maintain one power, then another, and then something different again. Instead of showing clarity, VT gives the impression that they are searching for a reason that fits. If a genuine offense had been clearly identified, the explanation would stay consistent. On top of that, none of the sections maintained suddenly grant the right to demand each personal details. Referencing different powers does not automatically create authority or it does not exist. The shifting explanations only make the situation appear less convincing.
Saying to you is because I've got reasonable grounds to suspect that you've committed an offence.
Yeah.
If you don't give me your details,
Yeah.
it may make your arrest necessary under section 24 of PACE.
Oh, okay.
Because your name and address cannot be verified.
Right.
And I suspect that you've committed an offence.
Well, that's the full explanation. Thank
Yeah,
you for
that's
that.
what I said to you the first time.
Well, I didn't get that
Can
explanation,
you
so maybe you
confirm-
didn't explain it
can you
properly, and maybe
confirm-
I didn't
Right.
understand.
Well, you understand it now, though.
I
don't
do,
you?
I do,
Can you just
100%. Yeah,
confirm-
yes. I can't believe she lied to you, and she's a sergeant. She's going around lying to you guys. Do you want me to show you the video?
No.
Is it because you know that she's lying?
I don't know that she's lying.
I think you know.
Okay.
I think you know. I think you do know.
We're literally just going off what we've been told.
Yeah, what you've been told is a lie, though, is what I'm saying. I could show you the video now and show you that she's lying. What do you guys reckon? Your personal opinion?
My personal opinion doesn't matter. I don't
No.
work. My personal opinion has to stay at home when I come to work.
Well, use your detective skills then. What do you think?
This is what I'm doing.
Yeah, yeah.
Speaking to you. To
Well, yeah,
find
I could
out
have
your
showed you the video.
to find out your version of events.
No, you know what you're doing is getting my details unlawfully.
Okay. I'm not.
But
I've already explained to you the reason why.
I could have showed you the video and then
fine.
you would have no reason to get my details.
If you're happy to show me the video, I'm happy to watch it. It's not a problem.
Well, there's no point now because you've already given my details.
This is the point where the idea of fairness starts to fall apart. He keeps offering the easiest solution: simply watch the footage. MT could quickly show what really happened. Yet the offer is turned down again and again. One officer even admits she is relying only on what she has been told, rather than checking the facts for herself. That approach is not a real evaluation of the situation. Each side of the story is not compared with their available evidence. Instead, the video that could see through the issue is pushed aside while its on-hand information is treated as enough. By ignoring the recording, they avoid anything that might challenge the version of events they are already following. Then something interesting happens. After they have already collected each personal details, the video suddenly becomes important. The timing speaks for itself. If the footage truly mattered to the situation, MT would have been reviewed right at the start. Looking at MT only at the end does not feel like a fair investigation. It feels more like an attempt to tidy things up after the main goal has already been achieved.
Now I won't get my £1,000.
You've offered to show me. You've offered to show me the video. Then that's fine.
Yeah. You see that your Sarge is a liar.
Well, show me it if you want to show me it. I'm not bothered.
Am I being detained?
No, you're free to go. Thank
free
you for
to
giving me
go.
your details. Just be careful where you're flying it.
No, I won't.
Obviously, bear in mind that side of the gate and the fence is private property.
Oh no, I've already been over there.
Right, okay.
Yeah, I'm going to go over again.
Right, okay.
Yeah.
But bear in mind that you may be spoken to again by an officer if it's deemed that your drone's interfering with any police activities or
Is it?
anything like that.
All right. Well, I've got permission to be here
From
from the Civil Aviation Authority.
okay, have you got that in writing? Have you got anything on you can show me to confirm that?
Do I need to?
Well, I'm not just going to believe you, am I?
Well, I'm not just going to believe you that your sergeant's a liar.
Okay. Well, I'm not going to get drawn into this back and forth with you.
You've already been drawn
I've
into it.
spoken to you. I've ascertained what you're doing. As long as you're not
Well, what
interfering
happened
with
to the
police
section
activities,
4A?
that's fine. I'm not going to take any further action against it.
No further action?
Yeah.
Why? Because you
I'm gonna give
know
words
that she's a
I'm
liar.
going to give you words of advice.
No, I don't want your words of advice.
well, I'm gonna offer
you
you
can
them.
stick your words of advice.
Right, I'm going
The moment they finally receive each personal details, the entire situation suddenly loses momentum. There is no longer any talk about pursuing IN airfence, no further steps suggested, and no real interest in continuing the matter. Everything maintained earlier public order concerns, serious accusations, and references to legal sections simply fades away. That sudden shift does not look like a coincidence. If those claims were truly important, they would not disappear the instant each information is written down. When INSUE is genuine, VT usually leads to more questions and follow-up actions. Instead, the conversation stops almost immediately. This makes it clear that the real focus of the interaction was getting each's identity. Once they hit each's details, the situation was effectively over. The legal terms mentioned earlier did not lead to any real process or outcome. They seem to serve mainly as pressure during the conversation, helping ensure that each's information was collected.
I didn't speak to anybody in any. She's a liar. I never told her to pee off. She's an absolute liar. I will be making a complaint. I will be suing. Thank you very much. What's your details?
6468.
From the station?
Yep.
Your details?
290.
From the station?
Yep.
And her details?
She'll find those out for you. I believe her name's Sergeant Wiltshire, or Wiltshire, my apologies.
Sergeant Wiltshire?
Yep.
And her numbers?
I don't know them.
Well, I need her numbers.
I don't know them.
We'll have to radio through then.
I don't know them.
She's the one that made the complaint. I need to make a complaint about the lying sergeant.
Just ask to speak to Sergeant Wiltshire. She works on Team 4 Patrol South at Ellen Road. That's all you'll need.
Well, can't you just radio through and ask for her details?
No, because she's not actually on duty at the moment, because she was in, as you said, she was in a civilian car in a civilian clothing, so she's...
You could ring the control room and ask what her call number is.
I can't do that at the moment because I'm too busy, but you've got all the details.
But you weren't too busy to come and stop to talk to me?
Thank you very much.
Yeah, see you later, sausages.
I prefer bacon.